the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good evening, and welcome to another Ask the Experts, where we air every Monday and Thursday night from 6 to 7. Tonight's the first Thursday of the month, and without a doubt, with all the shows that we do, this is the most popular show. Phone lines are already ringing already. This week, we got over 60 text, emails from listeners with their questions. And I want to introduce you to this is our community association law show. We were so lucky we got the top community association law firm, not just here in South Florida, but in Florida, because they also have an office in Tampa. And we have been doing the show for about 4 years. But if you have a question about your HOA or your condo association, give us a call here at 888-565-1470. 888-565-1470. Let me introduce you to our expert, senior partner of Kaye Rembaum, Robert Kaye, board certified Robert Kaye. Good evening.
Good evening, Steve. Thank you for all of that. I appreciate it.
Well, I wish all of our shows were as popular as this one. The phones ring, people write in. It's just amazing. And gosh, with COVID going on, I bet your phones are ringing off the wall. But before we go to the phones, let's tell everybody about Kaye Rembaum.
Okay, Bender Rembaum, as many of you I hope know, is a law firm that's dedicated to representation of community associations out of our offices in Pompano Beach, Palm Beach Gardens, and Tampa. We provide all level of services to community associations, be it dealing with issues on interpretation of covenants, handling violations within the community, collection of assessments, negotiations of contracts, addressing defective work within the community, dealing with long-term loan situations, special assessments. Everything that an association deals with on a day-to-day basis are things that we've been doing since 1992.
Well, you are the best, and we'll be talking about your classes that you're going to be offering this month. We get a lot of people who just write that went to your classes saying how much they enjoyed them.
We do appreciate that kind of feedback. We try to keep it fresh, we keep it informative, and we keep it entertaining as much as possible.
Well, we've got a board full of callers. Let's go right to the phones and start off with Dolores. Good evening, Dolores.
Hi, good evening.
You have a question for Robert?
Yeah, I'm calling in. I'm going to try to make it really quick. Basically, there's never been any maintenance on the piping in the condominium, and unfortunately, my unit is the first unit where the piping comes out the front of the building. There was a whole sewage backup. Everybody's unit came up out of both my toilets. The board did immediately get on it and is rectifying it. However, so my main question is, am I responsible, or do I have to reach out to my private insurance, my homeowners insurance, for the sheetrocking of inside the apartment, although all this was brought out due to the lack of maintenance? And if I do make a claim, and if they do cover it, now that means I'm going to get hit with a higher insurance when it comes up. So,
Well, if
um,
what you're talking about,
do I have to make a claim? I guess that's my question. Does any of this fall on me?
well, Dolores, when it comes to situations like you've described, the threshold question is going to be whether it was a maintenance issue or whether it was a casualty event, a sudden occurrence that was unanticipated. Insurance is going to address the casualty event, but if it's determined that it's a maintenance issue, then you look to what the documents provide for as to the responsibilities. If it's decided that it's a casualty event, the association's insurance should cover a good portion of the damages that you have experienced, but there are specific exceptions to that, which you would be required to make a claim against your own individual policy, such as your wall, floor, ceiling coverings, the cabinetry in your unit, personal property, things of that nature. Unless the association was negligent, and you can prove negligence, and as a result of their negligence, you experience the damages that you've identified. So those are basically the parameters that you're facing. You should put your carrier on notice just to make sure you have preserved your right to do that, because one of the things that carriers will do is if they don't get prompt notice of a potential claim, they could deny coverage that otherwise they would provide, because your policy requires you to tell them timely. They'll investigate, they'll go after the association if they think some of that is on them. Or you can just try to go against the association, but there is the possibility that there could be no coverage at all if it's determined to be a maintenance issue, and then for sure you want your insurance involved.
Okay. All right. Thank you very much.
All right, Dolores, thank you for listening.
Let's go to our next caller, Mary. Hi, Mary.
Hello.
You have a question for Robert?
Can you hear me?
Yes.
Okay. My question is, if the board member negligent and refused to open the books, then there was a DDPR citation and we had to pay, everybody had to contribute. Can we go after the individual board member who refused to open the books because he is selling his unit?
All right, so Mary, if I understand what happened, there was a request for access to official records that a particular board member in charge did not allow, which was contrary to the law, and that somebody made a complaint with the Division of Condominium, and they issued a fine against your community that everybody had to pay, because that's how community associations work. Is that correct?
Correct.
Okay. Well, individual board members are generally not personally responsible for damages to the association that occur because of their negligent conduct and even some intentional conduct, unless they were considered grossly negligent or willful disregard after being advised by independent counsel of what the legal obligation would be and chose to disregard it. Then there is the possibility, or if they took an improper personal gain. So from what you've described, it doesn't sound like the individual had a personal gain. He may have been informed of what the legal requirement was and chose to disregard it. So there is the possibility. But if you were to make a claim against him, the likely occurrence would be he'd refer that to the association's director and officer insurance policy, and the association could end up.
Policy.
Well, if you don't have that, well, that's negligence on his part as well, because you should. It is a requirement that associations be adequately insured, and director and officer liability is considered one of those items that should be in place for community associations. So the most important thing is that get him off the board and get people in there that are going to do the right thing under the law. And hopefully the fine that you experienced wasn't so significant as to cause any individual unit owner financial distress. You can consider pursuing him, but the likelihood of an actual financial recovery may be low.
Thank you.
Okay, Mary, thank you for listening.
You know, Robert, I want to go to Annette. She's been holding a long time before we go to break. Annette, are you there? Annette?
Did Annette give up?
I don't know. We don't hear her. Annette? Is she? No, okay. So we lost Annette.
Well, we can tell Annette about what classes we have coming up if she's still listening.
We've got to go. Is she there? Okay. So we got to go to break first. When we come back, we're going to talk about your classes. We're here with Robert Kaye of Kaye Bender Rembaum, one of the top community association law firms in Florida. If you have a question, we have one open line. If you have a question, you can call us here at 888-565-1470. And Robert, give everybody the number at the office.
You can reach us at 1-800-9. Well, now that I'm thinking about it, what is my 800 number? 974-0680.
And you give them your website address too, because you've got so much valuable information on your website.
The initials kbrlegal.com.
And we will be right back. We're going to talk about all the classes that you've got coming up. We'll be right back.
Kaye Bender Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kaye, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rembaum, Esquire. Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. Kaye Bender Rembaum assists clients in all matters of association representation, including, but not limited to, collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kaye Bender Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kaye Bender Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kaye Bender Rembaum today at 800-974-0680. That's 800-974-0680.
We are back. This is the Ask the Expert Show, where we have South Florida's finest experts in health, legal, financial, and home improvement. This is the first Thursday of the month, so we always have Kaye Bender Rembaum. And before we go to classes, we got Annette back. She has been holding for so long, so let's take her question first. Hi, Annette.
Hi, can you hear me now?
Hear you fine.
Oh, great. I don't know what happened last time. Thank you so much for taking my call. So I have a question about the association's right to deny an applicant, more specifically a rental applicant with an adverse background. I know there's some potential liability should we deny him. Maybe you can talk about it a little bit. And also I'd like to know if we're allowed to give the owner of the unit a copy of the background check, so he's aware of what we're seeing as well.
Okay, well, you have more latitude with a renter than you do with a purchaser. So that's good to be aware of that. Your governing documents will provide the overall authority, and they should indicate whether or not the association has a right to review a lease application and approve it, and the time frames that you have to do so are important to keep in mind. The criteria for disapproving a tenant will depend on how your documents are written, but generally a little broader than what we would experience for a purchaser, and that their backgrounds and things that you see, which for a purchaser may not be as relevant to you, could become more important for a tenant. In the old days, financial concerns was not there, but since the statute was changed to require tenants to pay assessments to the associate or their rent directly to the association upon demand when the owner's delinquent, their financial background becomes an issue as well and can be a basis for disapproval, even though they're not the primary that's owing to the association. The background check has to remain confidential to the board. You're able to notify the applicant that your adverse decision as to their application for lease was based upon information that you got from your independent investigative agency. You'd have to identify who that is and give them a way to contact so they can get the report, but you're not allowed to share it with anybody else. That's under the federal laws, the Fair Credit Reporting Act that applies across the country. So you don't want to run afoul of that. Depending on your county, you may have to provide certain information to the tenant when you choose to disapprove them. You obviously cannot make your decision based on any of the protected classes, race, religion, creed, even sexual orientation, and all of those. So your basis has to be reasonable. So is there a specific issue of concern that you're seeing in that?
Well, they're pretty much third-degree felonies, more of probably marijuana charges, but there's quite a few of them, so it looks like it's a repeated pattern.
Well, criminal background is one of those areas that falls into a gray area. First off, it has to be a felony conviction, not a charge, not a misdemeanor, but an actual conviction. And secondly, it has to be of such a nature so as to affect the safety and welfare of the community. Marijuana possession charges may not rise to that level, while sales and distribution charges definitely would. You have to tend to be a little more careful. Now, you also should know that a disapproved tenant lacks what they call legal standing, or the ability to challenge your decision. Only the owner of the unit can do that. So if you disapprove a tenant, they have no recourse against you unless they want to claim discrimination. And so as long as you're not dealing with anything that could be a discriminatory situation, then you should be okay. And in that overall process, we do not recommend a face-to-face interview before you do your decision, because doing so can create the ability to raise a discrimination claim. Because if you don't meet the people in advance and see them, how do you know certain things? Would you know their race? Would you know some of the things that people claim as their basis for discrimination? So it's best to have your interview after you've made your decision, as more of a meet and greet. Here's the rules, here's what you need to know, kind of a thing.
One of the things that has me a little nervous is that they did put on the application that the tenant is disabled, which made me even more nervous should we go and deny the applicant for the criminal background.
Well, the criminal issues that you've pointed out might create problems for you in a disapproval if that's all you have.
Yeah. Agree
this
with you
is one of those
100%.
this is one of those where you might want to keep your fingers crossed and let it go through.
Agree. Thank you so much for the reassurance. I appreciate
Thank
it
you.
greatly.
Annette.
Enjoy your show.
Annette.
Thanks for coming back to us.
Thanks, guys.
So even
Bye.
if the potential renter is disabled, would they have a problem denying them if it's on the application?
Well, it really has no place on the application, and they volunteered that information. It doesn't come in as a factor for their decision, and assuming that there isn't any issues with disability access in and out of it. You know, some of these older places may not be compliant with what the current laws require, and they don't have to be. But you know, it is just another potential to keep in mind if you see that that's something somebody could raise. So you want to be sure you have sufficient basis before you deny, and you also, you know, if you have a discrimination claim against you, what are the rest of the residents like? Are there others of the similar type of issue that they're raising? It would be a national origin if it's their disability. If you have others that are, then that helps to defend against a claim that you've discriminated on that basis.
Okay. Well, I ask all of our callers to be patient with us. We're going to go, we're going to talk about your classes coming up, and then we'll get back to the phones.
Sure. We have a relatively busy month, as there's a couple of expos we talked about last month. One of them was today, so hopefully enough notice went out for that. It was down in Miami. Next Tuesday, February the 9th, at the Palm Beach County Convention Center, there will be another expo from 9 o'clock to 4:30. We have two classes that we're teaching there. These are in-person instructors. We have guest restrictions at 10:30 in the morning, which will be taught by Allison Hertz out of the Palm Beach Gardens office. And then at 2:30 is the 2021 legal update, which addresses changes in the laws from 2020. They haven't met yet for 2021, so there isn't any there. That's it. At 2:30, there are continuing education credits for both, one for the guest restrictions and two for the legal update. And then the following week, February 23rd, there will be the Broward County Expo from 9 to 4:30 at the Signature Grand on 595 over there. The guest restrictions again at 10:30. This time will be taught by Andrew Black from our Pompano Beach office, and then the 2021 legal update at 2:30 by Michael Bender. On our Zoom schedule for the month, February the 16th at 5:30 to 7:30, we have an HOA board member certification. That will be taught by Emily Gannon out of the Pompano Beach office. And then on the next night, February 17th, actually at 3 p.m. Emily's is at 5:30, by the way, 5:30 to 7:30 on the 16th. On the 17th at 3 o'clock until 4:30, we have a new one, COVID vaccine, national relief, legislative updates for community associations. That will be, let's see who's going to be involved with that. Michael Bender, Jeffrey Rembaum, along with Congressman Ted Deutsch and Tim O'Keefe from a property management company. And then on February 18th, we're going to do a Zoom Ask the Attorneys without Michael Bender and Robert Kaye. We're going to actually do one with Jeff Rembaum, Peter Mullengarden, and Allison Hertz at 4 o'clock to 6 o'clock, February the 18th, Ask the Attorneys on Zoom. It's like our town hall that you love so much, Steve. Yes. Then on February 24th, At 1:30 to 3 o'clock on a Zoom, we have assessment collections and foreclosures 101. Allison Hertz and Sean Brown from our Tampa office will be discussing these issues and addressing concerns that people may have. For all of these upcoming events, you go to our website, kbrlegal.com, choose the KBR calendar on the menu bar, and then you can choose the event of your choice for pre-registration. Do it all online, and then you'll be there for those events. Busy month.
Busy month. Let's go to Mary. Hi, Mary.
Another Mary.
Hello.
Hi, Mary.
Hello, Mary.
How are you?
Good.
Doing good. How are you?
Very good. My question has to do with the board of an association. Currently, we have a husband and wife on the board, and one has to step down. And that one that stepped down is currently our treasurer, and she will remain treasurer but not a board member. My concern is, what limitations do we have to provide to her if she's no longer a board member? I have explained she won't be covered by insurance either.
Well, actually, that's not true. She would continue to be covered. Are you condo HOA, did you say?
It is a co-op.
Oh, co-op, okay. I should have offered that as well. Basically, you check your articles of incorporation and bylaws to confirm whether or not all officers have to be members of the board. It's unusual for that to be required. Typically, the president and vice president might have to be members of the board, but the secretary and treasurer do not necessarily have to be board members. Confirm in your documents if that's the case. If it's not requirement, there is no limitation on a husband and wife serving if one's a board member and one's an officer and not a board member. The only limitation is on them serving on the board together under certain circumstances, such as there's plenty of other people willing to serve. Or if they don't own two separate units. If they own two separate units, they can both serve on the board. Her being a
sold it.
All right, her being the treasurer, she still falls under the overall umbrella of being associated with your corporation as an officer, and as such, the insurance of the association would extend to her in that position as well.
Okay.
It's the job she'll do as treasurer will be the same as if she were a board member. She's just not voting on board issues anymore.
Right. So you don't feel that she should be limited in any way as far as she's still going to sign all the checks because she is the treasurer. But the rest of the board is thinking that she needs to be limited as far as calling the management company or asking for direction without going through the board.
Well, the board can limit what the officers can and cannot do at the discretion of the board, so long as they're able to perform their function of the office. It might require the treasurer to have access to the management company in performing the duty of treasurer for the financial information, or the manager, but it might not. So that's something that each community would address on its own. Depending on what your manager does, if your manager's on site and dealing more physical, obviously the treasurer has a more important role. For some communities, they have management companies that do all of the accounting, and the treasurer position is more almost just a formality, and they don't really do anything. It's all delegated somewhere else. So somewhere in between is where a lot of communities fall. And the board can do as the board feels as a majority is the most appropriate thing under the circumstances.
All right. Thank you.
Thank you,
All right,
Mary.
Mary, good luck with it. Thanks for listening.
So if you
You're
were
welcome.
on hold before and you want to call back now, our phone number is 888-565-1470. That's 888-565-1470. We're going to go to break right now. When we come back, we'll be taking more calls, and we get a ton of emails that come in with questions for Robert regarding HOA and condo
And
law
co-ops.
and co-ops. Yes, we can't leave that out either. Um, and we'll be right back with Robert Kaye. Give everybody the phone number at the office, Robert.
You can reach us for all three offices at 1-800-974-0680. You can send an email to info@kbrlegal.com or go to our website, kbrlegal.com, and there's a contact thing you can click on, and it sounds like we're going off. But
No, we're not. No. We got another 30 minutes. Okay, we're going to go to break, and when we come back, we'll have more with Robert Kaye of Kaye Bender Rembaum.
Kaye Bender Rembaum is a full-service community association law firm devoted to the representation of more than 1,200 community associations throughout Florida under the direction of attorneys Robert L. Kaye, Esquire, Michael S. Bender, Esquire, and Jeffrey A. Rembaum, Esquire. Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Kaye Bender Rembaum also keeps clients up to date on new developments in the condo and HOA law and how they are personally affected by them. Kaye Bender Rembaum provides prompt, effective, high-quality, cost-efficient, and understandable legal advice and services to a diverse client base. Call Kaye Bender Rembaum today at 800-974-0680. That's 800-974-0680.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
And we are back. If you're joining us right now for the first time, every first Thursday of the month, we have our community association law show. If you're a board member or you live in an HOA or condo and you have a question, we have the top law firm. And considering they're mostly all board certified, I can say this: they are the best. Kaye Bender Rembaum. They actually cover all of Florida, not just here in South Florida. And they also have an office in Tampa. If you have a call, you can call us right now at 888-565-1470. That's 888-565-1470. This is, with all of our 20 shows that we do each month, this is without a doubt the most popular show. I mean, we had to call down all the emails we got and texts we got, which we're going to try to get in now with Robert, and we'll be waiting for those phones to ring. 888-565-1470. Robert, the first question is, and I've never heard this before with all the shows we've done, a master association versus a sub-association. What is the difference?
well, many communities throughout the state are developed in tiers. Like you'll have a situation. There's one you might be familiar with called Eagle Trace. in Coral Springs. This situation, there's one association that covers the entire community, and then within that, there are subdivisions, different associations within the master association that they're referred to as sub-associations. When somebody lives in one of these neighborhoods within the master community, they're a member of both the sub-association and the master association, and likely will be paying assessments to both.
That's what I was going to ask. So that you got to pay twice, right?
Yeah, and there are some that will have a third. I've seen them with as many as at least three, and there could be. I mean, they can't add up, but they do different things. As you know, like with the Eagle Trace example, they're doing the perimeters that go around the gate entrances to the overall community. You could have condominiums within the community. You could have townhomes. You could have single-family homes. You can have portions of it that are just part of the master association, which I'm sure Eagle Trace does as well. So,
Robert, of all the places in South Florida to choose, you happen to choose where I live.
Do you think that was a coincidence?
I don't know, but you're right though. I mean, then I would be part of the master association, but those condos to the side, they have their own association too.
That's right. You go through the entrance. There's a steeplechase right there on the west entrance. That's a separate sub-association within Eagle Trace. So that's how that's set up.
Wow, I did not know that. That was from Justin in Boca. Here's Kevin in Boca. Says, I have a condo security question. And by the way, I would say probably 40% of the emails we get are people talking about how much they enjoy the show.
Only 40%?
Yeah, I know. But before I go to this question, I was just thinking, we get so many questions from owners that are very upset that they have to pay for amenities that they cannot use now. And they're really upset about that. We get a lot of those.
Well, that's understandable. Nobody wants to pay for things they can't use. But unfortunately, the laws are as they are, and the structures of the communities are as they are, and associations still have to pay what they have to pay. They have to maintain and upkeep these facilities, even though they're currently not available because of the situation with COVID. And so perhaps the assessments might go down a little because of the lack of the use, but maybe not, because the maintenance of these items may not differ that much. So that's just one of the downsides of living in a community association setting. If you don't like that, you can find a place that doesn't have a mandatory association, then you're not facing these types of issues. But down here, those are fairly few and far between.
Yeah, people are really upset about that, Robert. I mean, we probably got 10 or 12 emails, wondering what they can do. But like you say, there's not much they can do about it.
Well, just know it's temporary and there is light at the end of the tunnel. So we're told.
Okay, let's go to the telephones. We have a call from Tony. Hi, Tony.
Yes. Good. Hi. Good evening.
Good.
I just had a quick question about assessments. If you go through the violation process and the finding process, and the board approves the fine, I'm confused about whether a fine can be treated as an assessment against the dwelling unit. And I think I'm right. Fees can be assessed and treated as an assessment, I believe. Can fines be treated as an assessment?
Well, in a condominium, the answer is no. But in a homeowners association, it depends. There's a couple of things that have to exist in an HOA. One, your governing documents, your declaration of covenants has to expressly provide for the fine to be treated as an assessment and collected in the same way. And then the fine has to be more than $1,000 in order for it to reach the statutory minimum to become an assessable lien against the property. So condominiums, no. HOAs, sometimes.
Makes sense. Makes sense. Thank you. That thoroughly answered my question. Thank you very much.
All right. Thanks for listening.
Thank you, Tony. We have a line open at 888-565-1470. That's 888-565-1470. I started to go into Kevin's email from Boca Raton. Said, I have a condo security question. They never lock the doors in our building. We have found drifters sleeping because they didn't lock the doors. Does the board of directors have a legal responsibility to make sure the community is locked up and safe?
Well, the board has a responsibility to make sure the community is run in a safe and proper manner. Whether or not that means locking the doors is an issue of what's going on in the community. And in some communities, the answer is definitely yes, and others it may not be. The facts and conditions of the community have to be taken into account before you can reach a complete conclusion on that. Also, the physical layout of the community is an issue as well as to whether locking a particular door is going to provide the security that you're looking for. But as a general term, I would say that it makes sense for a communal building to have limited access and not be open to everybody to just come and go. And that's really more what we see. It's, I think, more of an exception what this writer is asking about.
Okay, we have an open line, 888-565-1470. If you have a question for attorney Robert Kaye Bender Rembaum. Here's a president of a small condo. And I'll bet you had a lot of calls on this. Can the board write rules and regulations on flying banners and flags? I bet you some of those were political and some of them were for sports.
Well, with respect to the board writing them, that is also going to depend on how your basic documents are set up. And you said a condominium, so the declaration of condominium has to give the board the authority to make rules and regulations that would encompass banning the display of flags or signs. The statute also provides that associations are not allowed to prohibit certain types of flags, the American flag, the state flag, certain armed services flags, as long as they're not too large. The statute provides for all of that in its parameters. Political signs is generally a problem more from the perspective of it's temporary, and by the time you can do anything on enforcement of them, the election is over and the signs would be gone. So there's no longer an issue that the courts would consider a controversy that they have jurisdiction to address. So that leaves the associations in a quandary of how they can enforce if they have such a prohibition on political signs. It's often better to set some time frames and parameters of how long they can display them and where they can display them, and then that makes it a little bit more easily enforced.
Okay. Let's, Vernita in Aventura. She said, I understand the emergency order is still on. Can we postpone annual meeting? Does that mean any meeting under the statute?
Well, the consensus of thought on meetings currently is that while we want to make sure that everybody's being responsible and maintaining the appropriate protocols of social distancing and mask wearing, the meetings still have to occur. They can't be just postponed. Many communities are using the technology, the Zoom type technology, to hold their meetings, with most participation being remote. And they're doing it successfully. So if you're able to access the technology to do that, that is the suggested approach to go. The board should also be meeting as well periodically and doing it the same way, because the business of the association still goes on. The board can't ignore annual meeting requirements and not hold elections. So, and with condominiums, the election procedure is set up such that people don't actually have to physically be there, because it's a mail-in ballot, and it's easily accommodated through the Zoom process. So we encourage the boards to consider that and take that approach for it whenever they can. If you absolutely are unable to do that, and you cannot safely hold a meeting, then you have no choice but to postpone it until such time as it's safe.
We kind of answered this question. This is Barbara in Coconut Creek. Love your show. I'm a unit owner and a new board member and a shareholder of a co-op.
Two co-ops today.
Yeah, our manager's agreement was extended, who is also a shareholder. The manager's brother is a board member. Isn't that a conflict of interest?
Well, it certainly looks like a conflict, but it doesn't necessarily mean one that would preclude the transaction from taking place. The cooperative statute does not currently prohibit a shareholder from being serving as a manager within the co-op that the shareholder is owning. It may not be the smartest thing to do on a personal level, because you can become like the superintendent, people knocking on your door 24/7. But the fact that the brother of the manager is on the board is just one board member. The key here is there be disclosure of the relationships prior to the decision being made, and that everybody's aware of it. If the membership objects, there are remedies available to them under the cooperative statute to challenge the contracts and cause them to be terminated, but it may not be warranted under the circumstances. If he's doing a good job, the fact that there's a relationship doesn't necessarily preclude them from going on in that fashion.
Our next one is from, I think this has got to be your cousin in Boynton, Kevin. He said, I never miss one of your shows. Our entire board listens to you every month. I know this is
I
your
hope they're there
cousin.
tonight.
Regarding board elections, we have several Canadians owners that didn't receive election notices. Does that disqualify the elections? We mailed it out 14 days in advance like we were supposed to.
Well, that's an issue that's a tough problem that many communities face, particularly those that have owners that reside abroad. The mail system, as we know, is currently not functioning as well as we would like to see it function. So while the law limits or requires you to give at least a 14-day notice, it doesn't say it can't be longer. And in a condominium, you can be as much as 34 days, because you've got to make sure you don't go beyond the time for people to put in their personal information sheet. But the more time that you can provide, the better your chances are that everyone can participate. But the board did what they were required to do. The association sent out the notice within the time frame of the statute, the fact that not everybody received it does not affect the ability of the election to move forward or invalidate it in any way. If there are owners that did not receive, they could have the information sent to them electronically, and then perhaps use an overnight delivery service to get it back if they're that motivated to participate in the election. The board also, we've had some clients that were facing that postpone the second half of the election, so that would give the people longer opportunity to receive and send back. And I have not seen that the Division of Condominiums has given an opinion one way or the other, but I think that they'd be inclined to find that an acceptable alternative, just extending the date, not changing anything, not giving anybody an opportunity to run who didn't timely put in their name, but just making sure that all of the owners have as much of an opportunity to cast their vote as possible without extending it indefinitely.
You know, I was kind of surprised, Robert. We used to be inundated by calls on emotional pets, and we don't get that many anymore. But here's one from Kim in Pompano, who did your condo class. She said, what happens when there's a pet that lives below and the person goes to work all day and the dog barks throughout the day? Is there any remedies for that?
Okay, well, again, you use the pet word when you shouldn't. An emotional support animal under fair housing laws is actually defined as not a pet, and you can have pet restrictions, but you can't restrict emotional support animals.
Okay.
The allowance for the exception to have an emotional support animal is not an unlimited opportunity for people to do whatever they want. The animal is not allowed to be a nuisance within the community, and there are remedies available to the association when the owner doesn't properly take care of their animal. Having an emotional support animal that you leave home alone all day does raise the question of whether there's actually that need for the emotional support animal, but that's an issue that would be a case-by-case basis. So if the dog, I assume it's a dog, is barking and making lots of noise and disturbing other residents all day long, the association can certainly address that. And if the owner doesn't resolve it, you can cause the removal of the problem. That has been done.
Okay. Well,
and bear in mind, we often see it's not the animal's fault. It's the owner.
Yeah, no kidding. Yeah, who leaves a dog home by himself all day long? But that we haven't had really any about emotional animals at all, and this was like one of the
Well,
first
I think word's
ones.
getting around.
Yeah,
Word's gotten out.
I apologize. We've got 3 people on hold. It's a fast hour. Robert will be back with us again the first Thursday of next month. And give everybody the phone number if they'd like to call and make a appointment for your classes, or if they're a board member.
You can call us at 800-974-0680. You can email at info@kbrlegal.com or go to kbrlegal.com, fill out the contact form there, and then somebody will get back to you immediately, if not sooner.
And I've got to throw this in because we've been doing the show for 4 years, and I'm going to tell you, if you're unhappy with your community association, law firm, or you'd like a second opinion, we have gotten nothing but rave reviews about Kaye Rembaum. So give them a call. I mean, it doesn't hurt. And we'll see you again next month, Mr. Robert.
And likewise, Steve, happy Valentine's Day.
Take care. And we'll see you guys next Monday with more Ask the Experts. Have a good weekend, everybody, and take care.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts.